Hello, friends. So far, the controversy over marital rape is concerned. Our society has been discussing it for ages. Recently, there has been furor in general public over the issue. A special bench of Justice Rajiv Shakdar and Justice Harishankar of High Court of Delhi had been hearing this matter for last few weeks. I do not claim to be a genius at all, but I am surely fascinated by a quote of Einstein in which he said that an intellectual would tell you how to resolve, whereas a genius would tell you how to prevent a problem. Hence, I am suggesting a prevention formula which surely would prevent many marital rapes. The point I am going to raise now hasn't been discussed by any of the parties to my knowledge, nor has it been mentioned in any of the articles I have read so far. According to me, there is a simple solution that would not only satisfy all the parties but would also be constitutionally valid and morally correct. Shockingly, the debate has so far not touched the point which I am going to raise here. This is the reason I have thought of sharing my views on this issue by posting them on YouTube to start a discussion. I would also send the link to the court masters of the honorable judges so that they may consider the points that I am going to raise here if they find them vital. Every prudent man would have to agree that women is not the property of man from any point whatsoever. No sensible man can deny the dignity of women. All the scriptures of the world, be it Hindu, Muslim, Sikh, Christian, Jainism, accorded a big status to women. Hindus we used to sing, उसको नहीं देखा हमने कभी पर उसकी ज़रूरत क्या होगी ए माँ तेरी सूरत से अलग भगवान की सूरत क्या होगी. Muslims they talk, they preach कि माँ के पाँव में जन्नत है. Jesus chose Mary to take birth, not John. Guru Nanak Dev Ji went a step ahead when he said that the society which does not respect women would not survive. I had the privilege of representing women lawyers of the Supreme Court before the bench of Honorable Justice Sikri, Justice M. Shah, and Justice Nazir, and they emphatically ordered to provide special status to women lawyers for allotment of chambers in the Supreme Court. Since time immemorial, many women have enjoyed exalted status. Justice Chaudhary of Andhra Pradesh High Court in the year 1983, in the matter of T. Sharitha versus Venkat Subbiah, rightly observed that sexual expression is so integral to one's personality that it is impossible to conceive of sexuality on any basis except on the basis of consensual participation of the opposite sexes. No relationship between man and woman is more rested on mutual consent and free will and is more intimately and personally forced than a sexual relationship. Recently, in Puttaswamy case, the 9 judges bench of Supreme Court reiterated the dignity of women. Similarly, in Joseph Shine versus Union of India case, while striking down the criminal prohibition upon adultery, Justice Chandrachud said, and I quote, the enforcement of forced female fidelity by curtailing sexual autonomy is an affront to the fundamental right to dignity and equality. In the matter of Harvinder Kaur versus Harminder Singh Chaudhary on 15th November 1983, reference AIR 1984 Delhi page 66, Justice A.B. Rohtgi very profoundly observed, and I quote, "The remedy of restitution aims at cohabitation and consortium and not merely at sexual intercourse. The court has neither the means nor the capacity to enforce its decree in the marriage bed. It is clear from Lord Stowell's decision in Foster versus Foster and Halsbury's statement of law that the court does not and cannot enforce sexual intercourse. Marriage has been described in these words: marriage resides in the procreation and education of children. Marriage has so far its object the mutual society, help, and comfort that one ought to have of other both in prosperity and adversity. Marriage is the most solemn engagement which one human being can contract with another. It is the contract formed with a view not only to the benefit of both the parties, but to the benefit of third parties, to the benefit of their common offspring, and to the moral order of civilized society. References to Shepherd on Marriage and Divorce, page 184, quoted in Waterley versus Waterley, 1946, to All England Reporter. Marriage means cohabitation. Cohabitation has been defined in these words. Cohabitation does not necessarily depend upon whether there is sexual intercourse between the husband and wife. Cohabitation means living together as husband and wife, and as observed in Evan versus Evan, 1948, 1 King Bench 175. Cohabitation consists in husband acting as husband towards the wife and wife acting as wife towards the husband. The wife rendering housewifely duties to the husband, and the husband cherishing and supporting his wife as husband should. Of course, sexual intercourse usually takes place between parties of moderate age if they are cohabiting. And if there is sexual intercourse, it is very strong evidence. In fact, it may be conclusive evidence that they are cohabiting. But it does not follow that because they do not have sexual intercourse, they are not cohabiting. The same view was affirmed in Watley versus Watley, 1950, 1 King Bench 39, as per Lord Goddard, Chief Justice. The restitution decree can't compel sexual intercourse by force of harm. The court ordered the withdrawing party to return to conjugal fold so that the consortium is not broken. Consortium means companionship, love, affection, comfort, mutual services, sexual intercourse. All these belong to married state. Taken together, they make up the consortium. Consortium has been defined as a partnership or association, but in matrimonial sense it implies much more than these rather cold words surest. It involves a sharing of two lives, sharing of joys and sorrows of each party, of their successes and disappointments. In its fullest sense, it implies a companionship between each of them, entertainment of mutual friends, sexual intercourse, all of these elements which, when combined, justify the old common law dictum that a man and his wife are one person. Crabtree versus Crabtree, reference is number 2, 1964, Australian Law Report 820, as per Justice Selby, on refusal of sexual intercourse. Justice A.B. Rothgi beautifully observed, from the definition, and I quote, from the definition of cohabitation and consortium, it appears that sexual intercourse is one of the elements that go to make up the marriage, but it is not summum bonum. This beautiful phrase is used, that it is not summum bonum, which means not the most important ingredient of marriage. We are all aware of many sexless marriages in this society which are keeping the flag of institution of marriage flying, even if it were flying half-mast. It is well settled proposition that the courts are not supposed to frame laws or legislate into subject, much less provide punishment for an offence which the Parliament has not provided. My considered opinion is that to decide the issue of marital rapes, the court is not at all required to frame laws. The basic rule which we all learnt in law school is taking the help of literal interpretation, which means that the plain reading of this section, if it conveys the will of the legislature, then there is no need to take recourse to any other rule of interpretation. The definition of rape, section 375 Indian Penal Code clearly mentions a man is said to commit rape if he penetrates his penis to any extent into vagina of women without her will or consent. The exception 2 to this section, which is being vehemently objected, says that sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape. This age has now been increased to 18 years as per the judgment in case of independent thoughts. It is very much clear that what is exempted is sexual intercourse with wife. Sexual intercourse presupposes some discussion, some dialogue, some communication, love, regard, respect, and willingness to have sex. So this is most important. Willingness to have sex. And as many songs convey us, the Hindi literature is full of this love. In Chitralikha, when the poet sings that सखीरी मेरा मन डोले, मन उलझे तन डोले, अब चैन पड़े तब ही जब उनसे मिलन होले. This is love. He says then it happens sexual intercourse. Or the poet says सजना है मुझे सजना के लिए. Or the other poet says रात पिया के संग जागी रे सखी, चैन पड़ा जो अंग लागी रे सखी. This is what they are talking. When they talk of sexual intercourse, there must be some dialogue, some background, some love, affection for each other. That is why many jurists have said that just by studying law or textbooks, one cannot become a great judge or a great lawyer or a great human being. You should know the truth of life, psychology of life, which is very important to understand in this code, in this matter. Like the poet says, धूप में निकलो, घटाओं में नहाकर देखो, और ज़िंदगी क्या है किताबों को हटाकर देखो, सिर्फ आँखों से ही दुनिया नहीं देखी जाती, दिल की धड़कन को भी रोशनी बना के देखो. Which means you can't see life and psychology just by these naked eyes. You have to make this heart as eyes. Listen from your soul. Then only you become a great judge or a great lawyer. That is why I mention these things in the context of sexual intercourse. What is sexual intercourse? Differentiating between sexual intercourse and forceful penetration is very clear. The exception does not say that rape by a husband is not rape. Rape is still a rape. It is simple interpretation. I really fail to understand how all these debates, articles, and arguments miss this vital point. That is why I said I am not claiming to be a genius, but the point I am raising may prove to be genius. I am of the firm opinion that no amendment or striking down of exception is required. The court only needs to clarify and interpret law. What is provided in exception is sexual intercourse. If there is no intercourse or exchange of thoughts and moods between the two individuals and the man forces himself upon a woman, it constitutes rape. If there is no intercourse before the sexual intercourse, that would surely mean rape. So absence of intercourse makes it rape. No prudent interpretation can allow immunity to a man accused of rape in marriage. It is violative of Article 21 and dignity of women. Sexual intercourse can never be rape. The Parliament has clearly defined the difference between sexual intercourse and rape. Like we can say, the example we can give, if Chinese forces enter Arunachal Pradesh, we say they penetrated into India jurisdiction. But if the Chinese premier is coming to India, we don't say he penetrated. We say he visited India. So this is the analogy to be drawn between sexual intercourse and penetration. Sexual intercourse is exempted, penetration forceful is not exempted. It is absolutely clear, therefore, to my mind, that the only thing the court is required to do is to clarify that even a married man can be accused of rape. It is not sexual intercourse. However, we must flag the issue that to safeguard the institution of marriage and false accusation in cases of married couples, the court must provide for stricter rule of proof or of evidence. Like there must be some indication of resistance or protest, injuries, scratches, etc. A simple statement of women in these cases should not be sufficient. The status of both the parties, track record of both the parties, etc., and otherwise they should categorically hold that even a married man can be accused of rape. So the marital rape exception, which is being criticized and rightly being opposed as many groups, should be immediately declared as a fallacy. I hope this view is considered. This would not only prevent many marital rapes but would also satisfy both the parties. And I, as a mediator or a conciliator, can also claim that this is a win win situation for both the parties. The main argument of petitioners in this case and women rights groups is accepted that woman is not property of a man and the law must ensure her dignity. Husband is not the owner of wife, and in case a man defaults, he must be prosecuted and punished. At the same time, there is no need to strike off exception and give an assumption of creating a new law which the parliament has not created. So it would satisfy the other party also. This way, the court would not be encroaching upon the jurisdiction of the legislation and would perform its true, solemn, religious, ethical, and moral duty to interpret the law. We should not blindly follow judgments and laws of foreign countries in this regard, although we keep learning from them, and I have also cited a few foreign judgments. But we can surely be cherry pickers. India has been a spiritual reader in many aspects, and this is one such sensitive facet of human psychology that we can lead the world. Thank you very much. I invite suggestions from friends. You can email me at Ashok Arora 2310 at gmail.com or WhatsApp me at +91 98 100 62089. Those who wish to read my views about marriage and sexual intercourse can read my book, which is available on Google on man women relationship, or watch a film which we produced on this how to prevent rape, Kasur Kiska, which again is available at YouTube. You can always write to me if you need any of these books or film. Thank you very much. जय हिंद, सत्यमेव जयते. आपका दोस्त अशोक अरोड़ा.